Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Purvang Kamdar. He is going to speak on challenges of enforcing arbitral awards in different jurisdictions. He is from KES Shri Jayantilal Patel College of Law. So without wasting further time, I would request Purvang to commence with his lecture. Thank you.
Good afternoon. Arbitration has become an increasingly popular method of resolving disputes, offering a faster and often more flexible alternative to traditional court proceedings. However, the enforcement of arbitral awards across different jurisdictions remains a significant challenge, particularly in a diverse and legally complex country like India. Despite the global push towards harmonizing arbitration laws through international conventions such as a New York Convention of 1958, the practical implementation of these awards can be fought with obstacles. In India, the enforcement of arbitral awards is governed by the Arbitration and Conciliation Act 1996, which aligns with international standards but also integrates unique domestic legal principles and procedural requirements. The Arbitration and Conciliation Act 1996 is a pivotal legislation in India that provides a comprehensive framework for arbitration and conciliation proceedings. Enacted to promote alternative dispute resolution mechanism, the Act aims to ensure the fair and efficient resolution of dispute outside the traditional court systems. It covers both domestic and international arbitration, allowing parties to resolve their conflicts through a neutral and binding process. The Act emphasizes minimal court intervention, thereby expediting the resolution process and reducing the burden on the judiciary. By incorporating provisions from international convention, it also facilitates the recognition and enforcement of foreign arbitral awards in India. Overall, the Arbitration and Conciliation Act 1996 plays a crucial role in fostering a conducive environment for arbitration, ensuring that disputes are resolved in a timely and effective manner. Place of arbitration. The Supreme Court has clarified that when an arbitration agreement specifies a place of arbitration outside India, the provisions of Indian Arbitration and Conciliation Act 1996 do not apply. For instance, in a case where an Indian company had an arbitration clause with a foreign company that designated New York as the arbitration location, the petition to the Chief Justice of India for appointing an arbitrator was deemed not maintainable. Now we will look historical background. In India, alternative dispute resolution (ADR) methods have a long-standing history. Ancient Indian civilization explicitly supports the resolution of disputes through tribunals, chosen by the disputing parties themselves. This system was reflected in the Panchayat, which functioned as a people's court. English law's stance on arbitration has varied over time, ranging from strong opposition to a more moderate acceptance. Common law courts were initially skeptical of agreements to resolve disputes outside the judicial system. The term arbiter originally referred to a person chosen to resolve a controversy regardless of law. Over time, arbiter became a technical term for someone selected under an established system for amicably resolving disputes. Arbitration, a term originating from Roman law, involves resolving a disputed matter through a selected individual's judgment instead of taking it to established court. Before the Arbitration and Conciliation Act 1996, in India was governed by three separate laws: the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, and the Foreign Awards Recognition and Enforcement Act 1961. The 1940 Act dealt with domestic arbitration, while the other two addressed foreign arbitration and awards. The Arbitration and Conciliation Act 1996 replaced these three acts, consolidating the legal framework for arbitration and conciliation in India. Arbitration and Conciliation Act 1996. The Arbitration and Conciliation Act 1996, in order to consolidate and amend the already existing laws relating arbitration, on 25th January 1996, the Act came into force. There is total 86 sections in this Act and is divided into 4 parts, in which Part 1 deals general provisions on arbitration, Part 2 deals the enforcement of certain foreign awards, Part 3 deals with conciliation, and Part 4 deals the supplementary provisions. Arbitration. An arbitration, whether or not administered by a permanent arbitral institution. Arbitration is the settlement of disputes outside of court by one or more arbitrators appointed by both the parties. Arbitrator. Arbitrator is a person who is appointed to determine differences and disputes between two or more parties by their mutual consent. It is not enough that a party is appointed arbitrator. Person appointed must give his consent to act as arbitrator. Arbitration is a form of alternative dispute resolution where parties agree to submit their disputes to one or more arbitrators who make a binding decision. The purpose is used to avoid the delays and costs associated with traditional court litigation. Arbitral Tribunal. An arbitral tribunal is a private panel of one or more impartial arbitrators assembled to resolve a dispute through arbitrators. It is a quasi-judicial body that has the authority of adjudicate civil disputes outside the traditional court system. Composition of Arbitral Tribunal. Composition of Arbitral Tribunal is governed under Chapter 3 of Arbitration and Conciliation Act 1996. The number of arbitrators can be one or more agreed upon the parties. Parties are free to agree on the appointment procedure. If they fail to do so, the appointment is made as per the Act. The central government has the power to amend 4th schedule, which provides the model fee schedule for arbitrators. Grounds for challenging the appointment of an arbitrator includes circumstances that give rise to justifiable doubts about their independence or impartiality. The challenge procedure involves notifying the other party and the arbitral tribunal within 15 days of becoming aware of the constitution of the tribunal or the existence of the circumstance. Functions of the arbitral tribunal. The key functions of arbitral tribunal include determining the rules of procedure for the arbitration proceedings, fixing the time and place for the hearings, deciding on the liability of arbitration related expenses, maintaining the confidentiality of the proceedings, rendering the final and binding the arbitral award. Objectives of the Arbitration and Conciliation Act 1996. The basic objectives of the Arbitral Tribunal are covers both international commercial arbitration and conciliation as well as domestic arbitration and conciliation, ensures the arbitral procedure is fair, efficient and meets the specific needs of both the parties, requires the arbitral tribunal to provide reasons for its arbitral award, ensures the arbitral tribunal remains within the limits of its jurisdiction, minimize the supervisory role of courts in arbitral process, allows the arbitral tribunal to use mediation, conciliation or other procedures during proceedings to encourage dispute settlement, provides that every final arbitral award is enforced as if it were a court decree, grants the same status and effect to a settlement agreement reached through conciliation as an arbitral award, treats arbitral awards made in countries that are parties to international conventions as foreign awards for enforcement purpose. Foreign awards must be made in a country other than India. Arbitral awards. According to Section 2, Subsection 1 and Clause C of the Arbitration and Conciliation Act, the term arbitral award includes an interim award. It means decision of a person to whom a dispute is referred to by the parties to the dispute. In other words, award is a decision of an arbitrator which is binding on parties to the dispute. The Privy Council in Laldas versus Bailal laid down that an arbitral award is equivalent to the judgment of a court. An arbiter makes or passes the award after taking into consideration various factors, that is statement of the parties, witness concerned, examining the relevant documents, etc. Essentials of arbitral award. An arbitral award must be in writing and signed by members of the arbitral tribunal. If there is more than one arbitrator, a majority of the arbitrators' signatures are sufficient, provided the reason for any omitted signature is stated. The arbitral award must explain the reasons behind the decisions unless parties agreed that no reason are necessary. The award is based on agreed terms under Section 30 of the Act. The award must state its date and place of arbitration as per Section 20. The award is considered to have been made at this place. After the award is made, a signed copy must be delivered to each party involved. The arbitral tribunal can make interim awards on any matter that might be part of the final award at any point during proceedings. Interest on monetary awards. The tribunal may include interest in the sum awarded for the payment of money at a rate deemed reasonable for the period between the cause of action and the award date. The sum awarded shall carry interest at 2% higher than the current rate of interest from the date of the award to the date of payment, unless directed otherwise. The cost must be fixed by the arbitral tribunal proceedings according to Section 31A. These costs include fee expenses of arbitrator and witnesses, legal fees and expenses for supervising the arbitration, administrative fees of the institutions, other expenses related to the arbitral proceedings and the awards. Types of arbitral award. There are various types of arbitral awards. First one is final award. It is the most common type of arbitral award. Final award resolves all the issues submitted to arbitration. Once made, the tribunal's mandate terminates concerning the issues decided unless the award is set aside or modified by a competent court. Interim award. Issued during the arbitral proceedings. Interim award address certain issues before the final award is made. This can include matters such as jurisdiction, provisional measures, or specific parts of the dispute. Settlement award. During the arbitration process, the parties may choose to settle the matter instead of having it adjudicated by the arbitrator. In such a situation, the arbitrator could assist the parties in arriving in settlement. If a settlement is arrived and the arbitrator has no objection with it, then terms of settlement could be made part of award. Additional award. When a final award has been rendered, but it is later found out that certain claims that had been submitted to arbitral tribunal were not resolved or adjudicated, the parties can request arbitral tribunal to make an additional award covering issues that have been left. Such request must be made within the 30 days from the date of receipt of final award. Now we will look legal framework for arbitral awards in India. Section 31. From form and content of arbitral awards. The award must be written and signed by the arbitrators. It must state the reasons up to which it is based unless the parties have agreed that no reason are to be given or it is an award on agreed terms under Section 30. The award must mention the date and place of arbitration. A signed copy must send to the parties who involved in arbitration. Section 34. Application for setting aside arbitral awards. An arbitral award can be set aside by a court on grounds such as one party was unable to make decisions for themselves, the agreement to use arbitration was not valid, one party didn't get proper notice about the arbitrator or the process, the award dealt with issues that weren't supposed to be settled by arbitration, the arbitration process or the arbitrators weren't chosen on agreed terms, the dispute itself couldn't legally be settled through arbitration in India. The award goes against what's considered fair and right in Indian public policy. Section 36. Enforcement of arbitral awards. An arbitral award is enforceable as if it were a decree of the court. If an application to set aside the award has been made under Section 34, The filing of such an application does not by itself render the award unenforceable unless the court grants a stay of the enforcement on a separate application made for this purpose. Section 37. Appeals. Appealable orders. Appeals can be made against orders granting or refusing to any measure under Section 9, setting aside or refuse to set aside an arbitral award under Section 34, granting or refusing to grant an interim measures of protection under Section 17. Further appeals. No second appeal lies from an order passed in appeal, but this does not affect or take away any right to approach the Supreme Court. Domestic and foreign arbitral awards. Domestic arbitral awards. Awards rendered in arbitration proceedings conducted within India and under Indian legal framework. Characteristics. Conducted within Indian territory under Indian law, enforceable as a decree of Indian court, can be challenged in Indian courts on grounds such as incapacity, invalid arbitration agreement, lack of proper notice, or public policy considerations. Foreign arbitral awards. Awards rendered in arbitration proceedings conducted outside India or under a legal framework different from Indian law, involving international parties. Conducted outside India or under international arbitration rules, enforceable in India under Part 2 of the Arbitration and Conciliation Act 1996, incorporating the New York and Geneva Conventions. Must meet criteria outlined in international conventions, such as a valid arbitration agreement and due process compliance. Indian courts can refuse enforcement on grounds such as incapacity of parties, invalid arbitration agreement, improper notice, or if the award is contrary to the Indian public policy. Case law. Bharat Aluminium Company versus Kaisar Aluminium Technical Service, 2012. Facts. Bharat Aluminium Company or BALCO, an Indian company, entered into a contract with Kaisar Aluminium Technical Services, a foreign company. The contract included an arbitration clause specifying that any disputes would be resolved through arbitration in London under the rules of International Chamber of Commerce, ICC. A dispute arose between BALCO and Kaisar regarding the performance of the contract. Kaisar initiated arbitration proceedings in London as per the arbitration clause. Issue. The main issue before the Supreme Court was whether Indian courts had jurisdiction to intervene in arbitral proceedings seated outside India, whether Indian law applied to the arbitration processes and the enforcement of the arbitral award. Judgment. The Supreme Court judgment in BALCO case addressed several key points. The Supreme Court held that Indian courts do not have jurisdiction to interfere with arbitral proceedings conducted outside India, unless expressly provided for by law. This upheld the principle of minimal interference by national courts in international arbitrations. The court clarified that Indian law would apply only to arbitrations conducted in India unless the parties had expressly agreed otherwise. In this case, since the arbitration was seated in London, the laws of England would govern the arbitration proceedings. The court reiterated that even when an award is made in foreign seated arbitration, Indian courts could refuse its enforcement if it is contrary to the public policy of India. The judgment underscored the importance of enforcing foreign arbitral awards in line with international conventions and treaties to promote a pro-arbitration stance. Challenges for enforcing arbitral awards. Legal challenges. Ground for refusal under the Arbitration and Conciliation Act 1996. Public policy. Allows courts to set aside awards that are contrary to the public policy of India. The interpretation of public policy can be broad and subjective, leading to potential refusal of enforcement. Patent illegality. Recent amendments have clarified that awards can be set aside if they are patently illegal. However, this ground is also open to wide interpretations. Jurisdictional issues. If the tribunal is found to have exceeded its jurisdiction or if there are doubts about the validity of the arbitration agreement, enforcement can be challenged. Procedural challenges. delays in judicial processes, interim relief and stay on enforcement. Practical challenges: asset identification and attachment, lack of uniformity in interpretation, time limits and delays, challenges under Section 48. Cross-border enforcement challenges: recognition of foreign arbitral awards, reciprocity and bilateral agreements, sovereign immunity, inadequate enforcement of arbitral awards. To address the challenges, several solutions can be considered. By making amendment on Arbitration and Conciliation Act, further refine Section 34 and 48 to limit grounds for challenging and refusing enforcement of arbitral awards, encourage adherence to international standards and best practices in arbitration law to improve enforceability, expediting courts procedures, strengthening international cooperations, addressing sovereign immunity issues, promotion of institutional arbitrations. Now, we will end the topic with a small conclusion. Enforcing arbitral awards across different jurisdictions presents a formidable challenge shaped by legal complexities, varying interpretations, and practical hurdles. The diversity in legal framework and regularity requirements among countries leads to inconsistent enforcement outcomes, complicating the predictability and reliability of international arbitrations. Judicial interpretations of international treaties like the New York Convention can diverge, introducing uncertainty into enforcement proceedings. Moreover, political pressures and economic interest may influence local courts, potentially compromising the neutrality of arbitration outcomes. The time-consuming and costly nature of enforcement, coupled with public policy expectations and reciprocity requirements, further obstructs the seamless execution of arbitral decisions. Despite this obstacle, effort to harmonize enforcement standards, enhance judicial training, and streamline procedural requirements are critical steps towards fostering a more effective and equitable international arbitration regime. Thank you.
Purvang, thank you very much. It was nice hearing about arbitration and more so the detailed manner in which we have spoken about arbitral awards, that is type of arbitral awards, domestic, international. So it was very nice to hear you on this topic. So thank you very much, and a small token from us to you. Hammurabi to you.